Again, it just tells the story of it's the evil and the ugliness of people's hearts these days is everywhere.
This is Franky Rose's Think Tank. Here's your host, Franky Rose.
Hey guys, welcome to the Think Tank. I'm just trying to get some things hooked up here. So are you guys all ready for this hearing? I'm really hoping that they plan on streaming it. It hasn't been posted all over the place, so a little disappointed, but let's see how it goes. Couldn't connect. Let's try this one. Might have to go without ears. Let's see here. Y'all doing good today? Let's get this party started. I think all I can do is hook them up. I think maybe it needs more juice. Yeah. So everybody's ready to get going on this? Like, wow. Jasmine. So we are just waiting for them to start the stream, and we're good to go. What are you expecting today? What are we expecting? So we know Turtle Boy is out and doing his thing. I don't know if we're going to have anybody show us what's going on around the courthouse. We ran into a no-name. Hey, Harley girl, welcome, friend. Chopper Dandy Jonathan first. I love it. So yeah, shouldn't be much longer, and we'll get going here. Harley girl, I do love a nice Harley. Doesn't even have to be brand new. Some of the older ones are pretty styling. So while we're waiting for this, I am just going to make sure that there's not another stream I can hook onto. We want a good stream, don't we? So what do you guys think about Stephen McDougal going to his arraignment naked? He chose to go with no clothing on. What's going on here? I heard another didn't. Hey, sweet misery. So yeah, we're just waiting. I'm hoping we can get some footage of outside to see what they're doing today. Let's see here. If I have to pay for these audio files, I'm going to have a word with the courthouse. But then again, it would be a copy, so maybe. Sounds awesome. Thanks for being here. Was that a hang up? Is that what it was? Thank you. Am I still chit-chatting? There we go. Thanks, Maxie. That's very true. That's very true. What do you got there, girlfriend? Give me that. Ah, yeah. Well, I think it depends on the area, to be honest with you, Chopper. Oh, I am so stoked. Let's get this party going. Come on, Boston. I'm just going to double check again, make sure there's not another stream. This one should be fine, but I thought there would be a lot more. I thought there'd be a lot more streams. It's funny how that works, isn't it? Checking, checking, checking. So, motion to dismiss is what this one is about, this hearing. I don't know how you feel about that, but I can't see it being dismissed. Not at this point yet. You know, I'd like to see the FBI finish with their report before we get too far into anything. Oh, nope. No, no. Thank you for that. Well, hello. Good to see you. Franky. It's because we want access, and we can't have access because of a roadblock that's in our way. Oh, okay. So what do you guys think? Motion to dismiss is going to be denied, do you figure? What's your thoughts? Depending on how it goes, there's new stuff out about Audrey as well. So we just might be touching on that in a bit. So what do you guys think about this hair that was allegedly found on the bumper of Karen's Lexus? What do you think about that? If there isn't sufficient evidence, they may choose to prosecute later. Yeah, absolutely. Yeah, I do. I see a denial as well. But, I mean, it'll be interesting, right? It's going to be an interesting one. You think it was a setup with that hair? Yeah, a lot of people would agree with you, my friend. I think I'll wait for all the evidence to be presented before passing judgment, as always. I like to speculate a little bit. I don't say things are fact, but I do like to hear everybody's opinion on what they're thinking. If they have DNA, she's done for. That hair could have been there for a week, yeah. I have serious doubts on a hair on the bumper after driving in a snowstorm days later. Yes, and they're also saying that there was glass on that bumper from the cocktail glass. How do you feel about that? Would there still be glass fragments on that bumper? Yep. No, all good, my friend. All good, Chopper. Yeah, they like their DNA, don't they? They absolutely do. What DNA could they possibly find of hers that would be present? Very true. Yep. It's like a puzzle. I want to see all the pieces. That's fair. I usually do the puzzle and I'm missing 5 pieces. Didn't come because, you know. Okay, so I'm going to go over here. So we looked at this yesterday or the other day a little bit. This is the vehicle that they're talking about, and they're saying that taillight there was smashed when she backed over O'Keefe. I don't know. We've been looking at it, but we're not quite sure. Is this? Yeah, it's exactly the same. Not too sure if, I mean, it looks intact to me, so I don't know what to think of that. So we got Karen Reed and Officer John O'Keefe. May he rest in peace. Turtle Boy just got out. I think it's been 3 days now. He's back out. And this is the house that the alleged party was at, and where there is a possibility that John O'Keefe was in a fight and didn't fare well. And this is the house that, like I say, the party was at. There's a lot of questions about this. There's a lot of questions. This is Chloe, the one that the defense is saying most likely bit John O'Keefe's arm, that those are not from being underneath of the Lexus. A lot of people have things to say right now. Stop the Canton cover-up. I would like to see, like I say, before any of this gets going, I would really like to see that FBI report. I almost think, we were talking earlier, Mexi and I almost think that that needs to be done before this trial even starts. Well, hello, Southern Gal. Welcome. Nice to have you as always. It's going to come down to what else happens between now and then. I think you're right. So as far as Turtle Boy, what are your feelings about that? Do you think that's interference of some kind? Or do you think that, I'm going to refresh this. Well, let's see here. I thank you for that, Dandy.
Good afternoon, Ms. Little.
Good afternoon, Your Honor. David Unetti for Karen Reed.
Good afternoon, Mr. Yannetti. Good afternoon, Ms. Reed. Okay. Oh, all right. So here comes Mr. Lally. Were you expecting him, Ms. McLaughlin?
Yes, Your
All right. I'm sorry. I would not have started. All right. So, Mr. Lally, if you just say your name for FTR to
Yes,
pick it
Your
up.
Honor. I'm Lally for the Commonwealth. Good
All
afternoon.
right. Good afternoon, Mr. Lally. Okay. So when we were all last in court on February 15th, there was obviously Mr. Lally, why don't you have a seat? A joint motion to continue the motion to dismiss and the motion for sanctions and disqualification, and have those heard on March 12th. So at the time, as you all remember, I said it was premature. So now we are in receipt of your motion to continue because of recent developments. So I'm also mindful, I did just this morning receive a letter from the Deputy U.S. Attorney, and she made it clear that the parties can make oral references to the contents and the materials and proceedings in this courtroom. But she also cautions that only is necessary to further the proceedings. So in light of that caution, I obviously have not seen and have no idea what these materials are. In light of that caution, what I'd like to do is set some dates. I do agree that we can hear that motion to dismiss, a motion for sanctions and disqualification. So I'd like the parties to, it says you received the information from the U.S. Attorney's Office on February 21st. And I know you outline in your motion that it's very voluminous.
That's correct.
All right.
Evening of the 21st, we basically have had access to it starting on the 22nd until today.
Okay, so that's why I'm going to give you until March 6th to file any supplemental memo or motion on those 2 points, on the motion to dismiss and motion for sanctions. So the defense has until March 6th to file any supplemental motions and memos on those 2. The DA has until March 11th to respond. And on March 12th, we'll have a hearing on those motions.
Your Honor, if I may be heard,
I have more of a scheduling order, and then I'll hear you,
I just
okay?
want to be heard on scheduling before we move off that topic, so thank you.
Yep, no, this is all the dates that we're moving, you move to continue, and these are the dates we're having. Do you want me to say them again, Mr. Jackson? So on March 22nd, all motions in limine must be filed. On March 28th, at 9 o'clock in the morning, we'll have a hearing on those motions in limine. On April 12th, there'll be a final trial conference at 9 a.m. And on April 16th, the jury trial will begin. So it's a 5-week continuance of this jury trial. So I'll hear you.
I appreciate that, Your Honor. Thank you for hearing me on the issue of scheduling. I just want to bring to the court's attention a couple of things. I appreciate the court accommodating us in terms of the motion to dismiss today. I was prepared to argue the motion to continue on that issue, unprepared to argue substantively the motion to dismiss.
We're
but
not.
I understand that, but for the following reason. We received 3,074 pages, 1.3 gigabytes of data. We've only had a chance to go through a smattering of that data so far, right?
Okay.
So a couple of transcripts, we've reviewed and looked at or put our eyeballs on the files, but not the substantive data contained within those files. And I would dare say that the Commonwealth is in the exact same position. There has been an additional TUI request by the Commonwealth that the court is probably not aware of. That came in on Friday. Ms. McLaughlin asked the U.S. Attorney's Office, pursuant to TUI, which is exactly the same protocol that we utilized to get these almost 3,100 pages of data. And so we're expecting that to be heard at some point through the U.S. Attorney's system. In other words, they're gonna have to go to the magistrate, deal with the TUI system the same way that it took place here. And that takes not days, but weeks, I expect. We also haven't finished the Bodhi protocol, which is the state's protocol with the crime lab that you're well aware of. I say that to say, through 2 years of litigation with the Commonwealth, just about 2 years of litigation, we've received a little over 3,200 pages of data. In one day, the defense was given 3,100 pages of data, and none of it appears to be duplicative. All of it is brand new, and all of it, Your Honor, appears to us to be exculpatory. The schedule that the court has suggested, although I'm mindful of moving along, I can't do it in violation of my client's due process rights. I can tell the court there is no possible way that we'll be ready for, just to grab my notes, there will be no possible way that we could have all of our motions written on this issue alone, just the motion to dismiss, by March 6th. That's
So
too big.
what I need you to do is put in writing why.
Sure.
All
Sure.
right.
I can tell.
I am very mindful, though, where the U.S. Attorney says we expect, of course, that the parties will disclose orally the materials in court only as necessary to further the proceedings. So put something in writing, get it to me by this time next week as to why you cannot be ready specifically. But I'd urge you to use that time getting ready. All right?
May I have just a moment to confer with
Yes.
counsel?
She doesn't look very happy. Do you think she's expecting that this will just be shut down without a trial?
Your Honor, thank you for accommodating that quick chat. I want to make sure that the court understands that in addition to, and that's what Mr. Yannetti was just urging me to bring to the court's attention. I don't want to speak for him, he can speak for himself. There is a motion to disqualify, which is also robust in scope and terms. He's going to be arguing that. That is yet to be on calendar, and he just indicated to me he does not believe there's any way that he could be ready on this briefing schedule for this kind of influx and incorporation of this level of data.
So
There's
you
gonna be-
can put that in writing as well, Mr. Yannetti.
That's fine.
I just want
Happy to do that.
I just want to put a sort of a precursor to the court. We expect additional rules based on what we've got so far. And I'm happy to describe a sampling of it if the court wishes. But based on what we've gotten so far over the last 48 business hours or so, there's going to be additional Rule 17 motions, significant additional Rule 17 motions. There's going to be additional Rule 14 motions. We're going to have to supplement the motion for disqualification that Mr. Yannetti just alluded to. We're going to need to supplement the motion to dismiss, which I'm alluding to. We will be filing a motion for extraordinary governmental misconduct based on certain evidence that we just received. And all of this has to predate any reasonable effort that we have to prepare for trial. So my suggestion, and we'll put it all in writing as the court suggested, but I can tell the court that based on what I know, and I know that the court is operating a little bit in the blind because you don't know what we know, what we have. An April 16 jury trial date is probably not realistic, but I will put all of that, as the court has directed me to. We'll put all of that in writing, and we will suggest what we think is a reasonable trial schedule and briefing schedule based on what we've just received.
Okay, so I need that by next Monday at the latest, okay? Ms. McLaughlin.
A week from today, yes.
Your Honor, if I may, the Commonwealth has had the opportunity to go through all the discovery that's been provided. It is voluminous. It is, there's a lot of material there. However, the Commonwealth would dispute counsel's representation that the material is new information. I would say approximately 90% to 95% of the material that we've received is consistent with the Commonwealth's theory of the case and the testimony that went to the grand jury of witness statements. There is some new information that counsel will use in their motion, and the Commonwealth understands that. However, I would say the evidence as a whole is very consistent with prior statements made by witnesses that testified for the Commonwealth. Thank you.
All right. All right, so put it in an affidavit by next Monday, but these days, as of now, these are our dates. Okay?
I want to make sure I got the dates, all the dates that the court indicated. March 6th for the motion to dismiss.
To file any supplemental memos on the motion to dismiss and the motion for sanctions, disqualification of the district attorney's office.
The next date, March 22 for motions, all motions in limine.
Yes, for
March 20.
filing all motions.
March 28 for hearing on all motions in limine.
Yes.
April 12, last readiness conference at 9 a.m.
Yes.
And April 16 for jury trial.
Yes. Okay.
Your Honor, if I may, I may not have heard. The March 12th date, was that 9 a.m. or 2 p.m.?
March 12th, we can go at 9 o'clock and we can take all day. So, all right.
Your Honor, what are the dates for the Rule 17s that we anticipate filing, which are we expect are going to be voluminous?
Why don't we do those on March 12th as well?
Okay, Your Honor, we have the calendar that the court has suggested, and we'll file our papers by Monday.
Great. We'll see you on the 12th. Thank you. All right. You want a short recess?
All rise.
Don't forget that we're doing probably Audrey Cunningham later in the day. And I could not find anything else that I thought maybe we should go through right now. But with that said, keep your eyes peeled. Don't forget to hit that bell, and I'll see you guys in the next one.